busted up train. Didn't plan on losing my heart tonight, but on that greasy rooftop it all felt right. On the roof of the Waffle House, love gets loud. While Dixon's in the kitchen, we escape the crowd. He might motorboat me like a big old beast, the Lord have mercy. He smells like he's might not be forever, might not be clean, but on that rooftop, I'm his queen. Don't wear pride, we climb that ladder just to let it ride. No white picket fence, no wedding ring, but the way you touch me makes the rafters sing. On the roof of the Waffle House, love gets wild. While Dixon's in the kitchen, we escape the crowd. He might motorboat me like a big old beast, but Lord have mercy, he smells like he might not be forever, might not be clean, but up on that rooftop, I'm his queen. I don't wear pride, we climb that ladder just to let it ride. No white picket fence, no wedding ring, but the way you touch me makes the rafters sing. Oh, leave the minivan, leave the 9 to 5, hop in your Beetle, let's feel alive. With Dixon, fried bacon, and the jukebox on, we found the kind of love that don't feel wrong. On the roof of the Waffle House, love gets wild. All two broken hearts, lost but proud. But tonight on this rooftop, he's my peace, my wreck, my home, my break routine. But on that dirty rooftop, I'm his queen. I'm his queen.
Good. Welcome back. Hey, little D. And now we're into the interpretive dance part of the hearing, because now it's time for the defense to call their witnesses. So are we going to get police officers in there saying, yeah, I use my personal phone all the time to text about all the cases I cover? Oh, interesting. By the way, you have a meeting with the commission next week because you're not allowed to do that. Or are we going to get... Who are they going to call? It's not Ghostbusters, I know that much. But if their defense is other people are bad too, will they then call people to say, yeah, I'm really a bad cop. I am the worstest. I have a hard time seeing where we're going with all of this, but if I learned anything from Canton, it is you'll be surprised anytime and anywhere, because I just... maybe they can find someone who wrote the manual and says, well, we didn't mean it to say this, and it can't be interpreted this way. But how does that prove that? Because they asked for 200 cases that they haven't had turned over. And yes, the poetic justice of Proctor crying about not having evidence turned over is not lost on me. And it's one of those things where you're wondering, how, what, who? Because there's really no real defense for this other than, well, I fucked up. And if they disciplined, are they going to call Kevin Albert and say, you only got 6 days for this, right? No, it was actually 3 days without pay. Oh, but you did this, and this. Is he going to plead the fifth? I don't know if you can do that in a civil hearing. But if you say, yeah, I did exactly the same thing, yeah, then they have no other option than to fire you. I have no idea where this is going, and it's ridiculous what we have wasted. How much have it been? Close to 6 hours on them asking stupid questions and never ever touching on the content that got him fired. The only thing they have touched upon is, hey, do you know that in subsection G on 2.5.6 it says nothing about cell phones? No, because that's implied. Yeah, but it doesn't say that. No, but it's implied. We all know we can't go to a bar and yell it. We can't write it on a telephone, and we can't put up a billboard. Help me out, chat. What am I missing? How are they going to save this one? I just don't know. I'm lost for words, and normally that's not my problem. Normally I can talk and talk and talk and talk, but I'm just wondering. Normally, when you see the cross-examination, you'll get an idea in what direction they're trying to steer this. And so far, the only direction has been, well, he didn't know he couldn't do it on his private phone. But that's like saying, well, I didn't know I wasn't allowed to use my handheld in the company car. I thought it was only in my personal car. No, you're breaking the law, asshole. It's I again, I don't know where we're going with this. It's redonkulous. They have no arguments. That's all I'm taking from it. Yeah. He lives on Drury Lane. Yeah, but the only argument is technicalities, and technicalities can be good, but the technicalities they are going for are, well, you didn't state it in your manual. He couldn't do it. No, but he can't share any information. And if he's not smart enough to figure out that, I can't text it either, then he should be fired for being too dumb to be a cop. Hey, Nicola Cooks. Think they are in denial that he was being investigated by the feds. Well, that's the thing. Oh, the feds had no rights to take his phone. Well, they did. Because the feds can take all your phones. And, he was complying. No, he wasn't. He was complying a year after when it was put into TUI motion what he did. He didn't come forward and say, oh, Jesus, boss, yesterday I was drunk as a skunk and I was really mad and I texted a lot of bullshit. No, he went to his boss when it was disclosed at the grand jury that they had his readout of his phone. That's very different. Very, very, very different. They do take an oath so he knows. Again, even if he says, well, I didn't read the manual. That's a part of your job description. And not knowing about the law doesn't make you not have to follow the law. It's the same. If I came to America and I was doing 100 miles an hour on the freeway and I get stopped by the popo and I say, well, I don't know your speed limits. I'm from Denmark. In Denmark, we can go 130 kilometers. So I was just looking at the speedo and thought, well, I'll stop at 100. Miles and kilometers, that's the same thing, right? No. Being stupid doesn't make you unable to get consequences. Well, they won't take him back, but they can be forced to take him back. this is what this hearing is about. The police is fighting not to take him back. But again, the Civil Service Committee can tell them, well, it wasn't a good firing. You can't fire him. You have to take him back. And then they'll have to take him back. They have no say in this. This is why we have this. The police have said, we can't use this asshole. But the Civil Service Committee can say, well, you have to take him back because it wasn't a kosher firing. But they don't trust him. They don't want to work with him. So he can go back and push papers till his pension comes in. And he's going to get off to Florida with $200,000 a year in income. Because that's what Brandon looked up. That's how much he's about to make in pensions. So I would fight to get my job back as well if I could get $200,000 a year. Yeah, ignorance. That's the word I should have used. Ignorance of the law is no excuse. They can't fire dumb cops. It's actually settled law that they can hire high IQ people to. They can't hire high IQ people. Well, I don't think, even though there's a lawsuit, I think they can hire anyone because you can't discriminate on base of IQ. Said to sister, don't tell anyone. Can't play dumb on that one, Michael. Exactly. He knew exactly what he was doing. He was sharing confidential information. He admitted he was sharing confidential information. He admitted that he put the police in a bad light because he was talking like a 17-year-old frat boy. So why are we here? If I walked into a police station and said, yep, you know that headless torso you found yesterday? I did it. Here's me on my phone filming me chopping the head off. And I then get sent to prison. It's really hard to appeal those types of cases because I admitted to the crime and I showed I did it. Him telling his sister, shut the fuck up about this, shows he did it. Knowingly that it was wrong. Pretty sure the rule the defense was quoting said any conduct at any time that brought ill repute to the MSP was an offense that he could be fired for. Yes. And then they went on to claim, but it doesn't say cell phone, does it? Which is a stupid argument because it's any. All time. Why are we here? Hey, Slidey Boy. Hey, Jen G. Heidi ho. Well, then you should sue them for discrimination.
Alrighty. There's one at the door, sir. I don't know if they're waiting for us.
Shut the fuck up, money.
Oh, okay. Thank you.
That's not nice. I like being paid, but shut up. Was it because I was talking in your chat yesterday? I should shut up. We are at a Civil Service Committee hearing. This is a hearing where civil servants can complain and say, hey, I feel this is wrong. They treated me wrong. And then the judge will look at it and say, yes, you're right. It wasn't a good firing. They'll have to take you back. So it's not the police. It's the Civil Service Committee that'll look at it, or whatever this branch is. So it's not the police who decides if he's going to come back. It is a judge who looks over these worker disputes. Hey, Sneaky. Oh, move it, right. as a fatty myself, I can say, hey, you put on a little window weight.
So good afternoon. The time is now.
I was paying you for your use of saying, shut the F up. Proud of you. Oh, you degenerates have made me more degenerate. Thank you again.
1:59 p.m. We're back on the record. And Mr. Monahan, will you
On the
finish with your
record?
questions?
I am finished.
Thank you very much.
Thank you.
Can we move on?
And Mr. Carly, do you have any redirect for Lieutenant Dwyer?
Yes, I do.
Please go
Woohoo!
ahead.
Redirect.
Thank you, ma'am. Detective Lieutenant Dwyer, good afternoon. Could I ask you first to please turn your attention to Respondents 18, Exhibit 18, page R0500.
Please no, I don't like her.
No, sir. All right, sir. Do you recall a series of questions under cross-examination where certain portions of your report here, portions of paragraph 21 were read to you?
Yes,
And you were asked if they were read accurately?
correct.
All right, so for completeness, could we go to the fourth line down on page R0500, starting with the sentence regarding?
Yes,
You see the word regarding?
I do.
All right. I'm going to read some of these sentences and just ask if I'm reading them correctly. So, regarding the information about the investigation that he texted, Trooper Proctor told investigators that he did not provide specifics besides the name of the decedent. While he may not have provided other specific case information to this friend group, he still provided information, including the cause of Mr. O'Keefe's injuries that had not been released publicly. Did I read that correctly, sir?
You did.
And continuing at that same point with the next sentence. The comment Trooper Proctor sent about Miss Reed being a, quote, whack job cunt, unquote, is an inappropriate and derogatory comment that shows Trooper Proctor had a personal dislike of Miss Reed. Trooper Proctor testified that his comments were partially due to his emotions getting the best of him. Police officers.
No, they never ever touch upon why he was fired. They are trying to go down the route of, well, paragraph 37-2/3 subsection G doesn't specifically mention a cell phone, so he can't be fired for that one. And then he was trying to make the lieutenant, sergeant, whatever he is, say something he didn't say. And I think we wasted 30 minutes talking about who was on a board and who could prove that people were on the board and if they were getting paid if they were on the board. It had nothing. It was 3.5 hours and it could have been done in 15 minutes. No relevance to why he was fired. It was just bullshit.
Have to act impartially and not based on emotion. However, police officers still experience emotions based on what they are exposed to. While this is understood, it is also understood that the emotions a police officer may feel about an individual are kept in check and their actions are based on reason and fact. Did I read that correctly, sir?
You did.
Continuing with the remainder of what you wrote in that paragraph, a few more sentences, sir. Did you also write, there is no evidence to show that Trooper Proctor's personal feelings influenced the actual evidence of the case, but the language used to describe Miss Reed is offensive and created the appearance that he was not impartial. Did I read that correctly, sir?
You did.
Continuing. Trooper Proctor's comments about Miss Reed, quote, excuse me, I'll restart that sentence. Trooper Proctor's comments about Miss Reed having, quote, a weird Fall River accent though, no ass, unquote, are inappropriate as they are a commentary on Miss Reed's appearance and mannerisms. Again, these comments are offensive and created the appearance that he was not impartial. Trooper Proctor's comments, quote, she's got a leaky balloon knot, unquote, and, quote, leaks poo, unquote, are commentary on Miss Reed's medical conditions. In his interview with investigators, Trooper Proctor acknowledged that the comments were unprofessional and regrettable. Not only are the comments offensive and unprofessional, but they are also medical issues that he disclosed to a group of people who were not privy to it. Did I read that correctly, sir?
You did.
And that was the complete portion of that paragraph, beginning with the word regarding and going all the way to the end of the paragraph.
Correct.
If I could ask you to turn your attention a few pages later to R0503. Do you see paragraph 30 on 0503, sir?
I do.
And it's fair to say you were also asked a series of questions about part of what you wrote in this paragraph.
Yes.
All right, I'm going to ask you to follow along, and I'm going to read aloud from this document, and you tell me if I read it fully and correctly, sir. After reviewing the testimony provided by Trooper Proctor related to the text messages about Miss Reed that Trooper Proctor sent, as well as information he provided to investigators, and considering the ramifications of his actions, it is clear that Trooper Proctor's behavior was unprofessional. His actions created an image that he was not impartial in his dealings with Miss Reed. It is entirely reasonable that a police officer may have personal feelings about an individual, but a police officer must act solely on fact and reason. While there is no evidence to show that the police actions taken by Trooper Proctor were directly influenced by his personal feelings about Miss Reed, his conduct demonstrated that he acted in an unprofessional manner that was demeaning to Miss Reed and cast the department into disrepute. Is that the entirety of that paragraph, sir?
It is.
Thank you. Now, sir, in the same set of documents, again, respondents' exhibits, the binder you have in front of you, could I ask you to please go to R481, please? R0481. I believe it is 15, sir.
15?
Let me
Well, on a positive
I said
note, we have started playing the cup in Danish football, and my team is up 7-0 at halftime.
Thank you. Thank you, Madam Commissioner. All right.
Okay, I'm there.
0481, sir, Exhibit 15. I want to ask you, before I refer you, first of all, what is Exhibit 15, just to clarify for everyone?
It is a transcript of the interview that we conducted with Trooper Proctor.
And this would otherwise be known as the OPIA interview conducted in this case?
Yes.
As part of your investigation?
Correct.
Okay. And I think earlier you testified, and correct me if I'm wrong, this interview was audio recorded?
It was.
And it was also then reduced to this transcription as well?
Correct.
During the course of your entire investigation, not just this interview, when, if ever, did the discussion or the topic of the February 8th, 2024 meeting between Michael Proctor, his attorney, and members of the department, when, if ever, during your investigation, did that subject come up?
To me, during this interview.
All right. To your knowledge, or as in your training and experience, and given your entire knowledge of your entire investigation, is it your belief that this is the only place in your investigation where this subject came up?
Yes.
Okay. And with respect to these pages of the transcript, starting with 0481, there's a series of questions, both by yourself as investigator, a fellow investigator, and counsel for Mr. Proctor on this page and the next 2 pages. Is that accurate?
Yes.
All right, sir. And referring you specifically to 481 through 483, this is the part that you were referring to where this subject came up, sir?
It is.
All right, sir. And just with respect to the introduction of the subject, starting with line 4 of 481, I'm going to read it aloud, and again, if you would tell me if I read it accurately, sir. Question. So you said on February 8th, 2024, you met with Attorney Staples and Kelly and DeStefano about the text messages. Was this a breakdown of all the text messages within your phone, or just what was brought up at trial, essentially? And then at line 9, the transcript indicates Attorney Moynihan says, this was in February of 20, and then it cuts off. And continuing with line 11, you state this was after the grand jury. In terms of lines 4 through 11, did I read that accurately?
You did.
All right, continuing on, sir. The line 12 begins with question after grand jury, yes. Is that accurate?
Yes.
And then there's some back and forth between, on lines 13 through 18, there's some back and forth and some crosstalk between yourself and Attorney Moynihan. Is that accurate?
Yes.
All right. And reading the portions of lines 15, 17, and then 19 through 22, your question that's next stated is effectively as follows. And again, please tell me if I misquote anything. Question, but I mean, now he knows what was brought up in trial, so what you learned at that meeting, was it just a discussion of essentially what then came out in trial, or was it about a lot of text messages, other text messages? Did I read that accurately?
You did.
Then, beginning with line 23, there's an answer from Michael Proctor. Answer. So that February meeting was after I testified at the federal grand jury. And it was a discussion about the messages, how they were unprofessional and how they could potentially be interpreted. We decided to go into content. I've ended there at midway through line 2. Is that accurate?
Yes.
All right. And after Trooper Proctor indicated in that statement that he had decided to go into content, he takes it a different direction and says, I mean, we, Attorney DeStefano and I can't remember specifically what I shared, but they didn't really want to hear the full content at that time. We provided some examples, but we didn't go through like every single text. Did I read that portion of lines 2 through 7 accurately, sir?
Yes.
Then picking it up again with line 8, question. They didn't have a breakdown of every text. They just had what was presented at, and then you're cut off. And Mr. Proctor answers on line 10, not to my knowledge. I didn't know if they, and he's cut off, and there's some crosstalk. And picking up with line 12 with Trooper Proctor's answer, if, yeah, I don't know what was provided to them at, what point.
And what we know is that not everything has been provided, because apparently, by mistake, Aiden was given some texts that's impounded, so we can't hear what's in them. But apparently, he says they might be a little spicy, like a spicy meatball. I don't know why Italians would eat spicy meatballs. I never had a spicy meatball in Italy. I might just be a retard.
Did I read that accurately, sir?
You did.
All right, sir. And then on line 14, Attorney Moynihan, based on the transcript, interjects by saying, I have a question if you're done. Did I read lines 14 and 15 accurately?
You did.
And then the answer comes back from Detective Lieutenant Sweeney on line 16, yes, I'm done. And then the questions pick up in the transcript, starting on line 17. The questions now for this next portion are questions posed by Attorney Moynihan. Is that accurate according to the transcript?
Yes.
All right, beginning line 18, now under questioning from Attorney Moynihan. Question. At some point thereafter, did they get the specific text messages? Answer, yes. My understanding is question, in March. Answer, correct, sir. And then a question is interjected by a different participant, Detective Lieutenant Sweeney, on line 23, who got the text messages? Question, again referring to Attorney Moynihan, the legal department. Then Detective Lieutenant Sweeney interjects another question on line 25. All of them? Did I read that accurately through line 25, sir?
You did.
All right, and the last few lines here, sir. Beginning at the top of 483, beginning with line 1. Question, again referring to Attorney Moynihan. That's what you were told, correct? Answer, yes. I was informed that by Attorney DeStefano that MSP Legal met with ADA Lally and ADA McLaughlin was read in the full content of the messages. Then on line 6, sir, you interject. Yes, I think for clarification purposes, the department didn't receive anything. They were verbally told, and then you're cut off. Michael Proctor answers on line 9, correct. And your question continues, or your statement continues on line 10. What was the content of the messages? And on line 12, Michael Proctor answers, that's my understanding. Did I read that accurately, sir?
You did.
All right. Other than that portion of the transcript and that portion of the interview, do you have any personal knowledge as you sit here, sir, of what took place in the meeting between Michael Proctor, his attorney Michael DeStefano, Major Kopenrath, and staff from State Police Legal? Do you have any knowledge of what took place in that meeting, other than what comes from this portion of the transcript on February 8th of 2024?
I do not.
Right. So in terms of questions that you were asked on cross-examination about, well, you weren't aware at the time, but you're now aware of that. Do you recall those questions, sir, in that form?
Yes.
The answers you gave to those portions of the questions, or those questions posed to you on cross-examination, did those come from your personal knowledge or from essentially hearsay and rumor around the department?
It was from rumor.
All right. And those answers you gave to those questions, that was not based on any investigation that you performed. Is that accurate?
Correct.
All right, sir. I want to switch topics now and ask you about a series of questions you were asked on cross-examination concerning the timing of the duty status hearing for Michael Proctor. Do you recall a series of questions on that subject?
I do.
All right, sir. I want to ask you, before getting into the specifics of the timing of duty status in this case, some general questions, if I may. First, you subjects of, based on your training and experience as an internal investigator for OPIA within the Massachusetts State Police, you subjects of internal investigations by OPIA have certain rights under the collective bargaining agreement and department rules and regulations.
Yes.
All right. And in fact, during cross-examination, is it correct to say that you were asked a series of questions by counsel about some of those rights?
Yes.
You recall questions and answers related to due process rights of the subject of the investigation, things of that nature?
Yes.
All right, sir. Is it fair to say that some of those rights come into play once a subject is brought forward for a duty status hearing?
Yes. That would be accurate.
Okay. And if they have their duty status changed, if a given member has their duty status changed, based on your training and experience, do some of those rights under the CBA and under Massachusetts State Police regulations kick in at that time?
Yes.
All right, and would one of those rights be presenting the subject with evidence of the misconduct that is the basis for the allegation so that they can defend themselves during the disciplinary process?
Yes.
All right, sir. And you know that to be a right that subjects of internal investigation that you pursue have in your investigation?
Yes.
And you also know that Michael Proctor had that right as well as one of the subjects of one of your investigations.
Correct.
Did you, or to your knowledge, did anyone at the Department of Massachusetts State Police have documentation, physical evidence or documentary evidence of the alleged misconduct, the alleged text message misconduct, either at the meeting in February 8th of 2024, or the Colonel's meeting that you mentioned before, March 4th of 2024?
None that I'm aware of.
All right. And based on your understanding of the non-disclosure agreement that you described previously in your testimony, were you permitted to do anything with that information other than open an internal investigation at that time, meeting March 4th of 24?
No.
All right. Had any documentation as of March 4th of 2024, had any documentation been provided to you or to your knowledge, anyone else within the department, underlying the allegations of inappropriate and disparaging text messages by Michael Proctor?
No.
So there was no documentation provided to you,
Correct.
and you were the assigned investigator in that matter.
Correct.
Didn't his defense say that he turned over everything willingly and they didn't even have it at the first meetings? So, because it's not illegal to call someone a flat-assed nutbag. So, and there's nothing in the text that rises to anything criminally. I'm allowed to talk bad about people. If not, Marissa would be in prison because she talks bad about me every day. But he claimed they turned over everything and we corroborated, but the investigation didn't even have the text messages. Only the feds had those.
Would, if documentation had been provided and shared with the department, would it have come to you as the assigned investigator?
Yes.
Based on your understanding of the NDA, were you allowed to share even the existence of the allegation of inappropriate text messages outside of the group of people who signed the NDA?
No.
When was the first time, sir, as the assigned investigator, when was the first time that you received actionable information and details about that alleged misconduct by Michael Proctor via the text messages that allowed you to move forward with your investigation?
When Trooper Proctor testified at the criminal trial.
As you understood the NDA, sir, you were not in a position to move forward with your investigation until you received Michael Proctor's public testimony about his conduct.
Correct.
And the department could not bring Michael Proctor forward to relieve him of duty, whether it be restricted duty or suspension with or without pay. It could not do so until it could provide the subject with documentation to support the accusation of misconduct.
Yes.
Yeah, this is what I believe, that when they're talking about the NDA, I think they're talking about that gag order that the State Department put on the TUI requests. Or the TUI material. It wasn't a request, they had gotten them.
All right, sir, I want to ask you about the charges. You were asked a series of questions about Article 5. Do you recall some questions about that, sir?
I do.
All right. I ask that you go please to Article 5, which is Respondents 24.
I'm there, sir.
All right, and for council and the commission's benefit, that's R0642 is the first page. All right, sir. You have, let's call it 0642 is the cover page, 0643 is the first page of content from Article 5.
Yes.
Okay. Could you read it's a very short, it's a very short thing, but just 5.1, if you could read, not 5.1.1, just 5.1.
5.1 is titled Violation of Rules. Members and civilian employees shall not commit nor cause to be committed any acts or omit any acts which
Most likely not, because this is not. I know everyone wants this to be a big federal case, and the feds are going to come Monday. The feds don't care about this. This is a policy matter internally in the MSP. They don't give a fuck. If they're interested in anyone, it'll be in DA Morrissey. The only thing they can use Michael Proctor to is point the finger at DA Morrissey. And they haven't given him any offers so far for immunity, so they have nothing. I still believe that the Norfolk County DA office is under the scrutiny of the federal government, but it's not related to Karen Reed case. Karen Reed, she was found not guilty. They don't give a fuck about that. And I know I'm the boring guy to follow because everyone wants it to be, oh, they're going to come in and help Karen Reed and do this and do that. They don't give a fuck. Karen Reed was just a DUI case that, oh, something fishy was going on. They don't care. This is a civil matter. It's work-related, has nothing to do with anything. If anything is going to happen, it has to be through the Sandra Birchmore, because that's the only case they have done anything with so far. And I think Karen Reed got their notice while they were looking at the Birchmore, because it's the same players. I think they still look at the Norfolk DA's office, but it's not going to do anything with the Karen Reed case. Nothing. I don't believe that it has anything to do with that.
constitutes a violation of any Massachusetts State Police rule, regulation, policy, procedure, order, or directive.
All right, sir.
Yeah, because the only reason why they would ever do anything to Proctor is if they want to force him to sing about orders given by DA Morrissey that help cover up cases or payments or something. This is a ridiculously small, stupid office dispute. The federal government doesn't give two shits about this. We do, because we're very invested in the Karen Reed case, but that's why I spent a lot of time doing my first show saying I really wish more creators would be as dour and grumpy as I was, instead of giving all of you people the belief that the feds are going to come Monday. It's not going to happen. They don't give two fucks about this. If they wanted him arrested for anything, he would have been arrested by now. He got fired. They said, well, fuck that. We're out of here. She got found not guilty. If they really wanted to do anything, I love that thing where someone said, well, Karen Reed it went to court because the feds wanted to impeach people after. You can't do that. Just telling people that happened is, you're praying that your audience are too dumb to think about it. Because what happened if she was found guilty in the court of law? They don't run a trial to try and get someone nicked. The problem is, people know that people really hope that the feds will be the cowboys in this one and come riding over the cavalry, come riding over the horizon and save you from the attack by the natives. But it's not going to happen. Michael Proctor, unless he's going to sing about Morrissey, is done in the eyes of the feds.
And could I refer you then to R0644, the next page,
I know I'm boring.
specifically 5.3. You see 5.3 general
I just
conduct.
wish more people would be
Could you
boring.
just read
Because
very
you
briefly
people get too
that
much
one
smoke.
sentence, general conduct?
And you have to learn.
Members shall maintain a level of conduct in their personal and business affairs which is in keeping with the highest standards of the law enforcement profession. Members shall not participate in any act which impairs their ability to perform as members of the state police or causes the state police to be brought into disrepute.
Now I'd ask you to please, to drill down on this a little bit more. Please go to R0645.
I tried to be.
It's page 3 of that particular document. You have 0645, sir?
I do.
All right, looking down at the bottom of 0645, 5.8 is titled unsatisfactory performance, is that right?
Yes.
And 5.8.1, could you read 5.8.1, please?
Yes. Members shall maintain sufficient competency to properly perform their duties and assume the responsibilities of their positions. Members shall perform their duties in such a manner as will maintain the highest professionally accepted performance standards in carrying out the functions and objectives of the state police.
So, could you then continue on to the next page, R0646, excuse me, R0646, 5.8.2. You were asked a series of questions about 5.8.2 in particular as well, is that right?
Correct.
Could you just read for us the complete text of 5.8.2, and then I'll have some follow-up questions.
Unsatisfactory performance may be demonstrated by a lack of knowledge of the application of laws required to be enforced, an unwillingness or inability to perform assigned tasks, the failure to conform to work standards established for the member's rank, title, or position, the failure to take appropriate action on the occasion of crime, disorder, or other condition deserving state police attention, or by an absent without leave.
Thank you for reading that, sir. Series of questions for you about 5.8.2 in particular. Understanding your earlier testimony that you are not assigned responsibility for what charges are brought during the disciplinary process. You're only assigned to the investigation and to either sustain, not sustain, or exonerate on each individual allegation, factual allegation. Understanding that, sir, do you see the portion of 5.8.2 that says unsatisfactory performance may be demonstrated, and then it proceeds from there?
I do.
All right, sir. Is your understanding that unsatisfactory performance may be demonstrated? What follows is a list of possible ways in which 5.8.2 can be violated?
Yes.
All right, sir. It is not your understanding that that is an exhaustive list?
Correct.
All right, sir. With respect,
Did I gain understanding of the U.S. justice system just by watching proceedings trials? Yes. I'm a big nerd, and I've been doing jury duty for 14, 16 years, so I'm kind of a nerd. And it's not that hard to pick up what an objection is and what the sidebar means. The rest of it, I'll just flunk. But police is the same everywhere around the globe. It's not your police that's just bad. There's also bad cops in Denmark, so it's really easy to talk about. But it makes me a dour fuck sometimes.
to the questions you were asked about 5.8.2. Do you recall a series of questions on cross-examination where you were asked to go down and after each one of those clauses, each one of those sections under 5.8.2, you were asked, effectively you were asked, did you find any evidence in your investigation to suggest that Michael Proctor violated this portion of 5.8.2? Do you recall that series of questions?
I do.
Did I characterize those fairly, sir?
Yes.
In your view?
Yes.
With respect to your answers to those questions on cross-examination, sir, can you explain how you were answering those questions? What did you mean by your answers? You did not find anything with regard to Michael Proctor's performance of his duties as a Massachusetts State Police detective assigned to Norfolk County.
Yes. So my investigation was focused on the allegations over the text messages. It was not on any aspects that Trooper Proctor took in furtherance of the criminal invest. So when I was answering those questions, I was referencing the fact that during my investigation, I learned nothing to suggest that any of his actions impacted any of the investigative steps taken during the invest.
All right, sir. Does it therefore follow from that testimony, sir, that you are saying that there's no evidence of a violation of 5.8.2 at all?
No.
Okay. With respect to, for example, in 5.8.2, failure to conform to work standards established for the member's rank, title, or position. With respect to that, going beyond just the specific investigative steps that you're aware of or became aware of during the course of your investigation, are you aware, based on the conclusions of your investigation and the evidence gathered, of a failure to conform to work standards established for the member's rank, title, or position in that broader sense of Trooper Proctor's duties?
Yes.
And earlier you were asked a series of questions regarding your familiarity with Article 5. this document here, Exhibit 24. Do you recall being asked about your familiarity with Article 5 in general?
I do.
All right. And with respect to your familiarity with Article 5, it's fair to say that all members, not just internal investigators, are required to be familiar with Article 5. Is that an accurate statement?
Yes.
All right. With respect to all members being familiar with Article 5 and your knowledge of Article 5 in particular, sir, is there any portion of the sections we just read or any portion of Article 5 that says members shall perform in the following way except when on a personal cell phone?
No.
Does it say except when texting with one's high school friends?
No.
Does it say except when you're stressed or angry at a suspect?
No.
All right, sir, I want to change gears, if I may, and ask you a series of questions with respect to the interview that you referenced earlier. The interview with Mike Proctor took place
we're
July
up
19,
9-0.
2024. Is that accurate?
Yes.
Do you recall a series of questions on cross-examination from Attorney Moynihan about the timing of setting up that interview and specifically a conversation you had in conjunction with the duty status here?
I do.
All right, just to refresh everyone's recollection and the commission's recollection, what was the date of Michael Proctor's duty status hearing in this case?
It was the first.
Well, so the administrative leave went through on July 1st.
Yes,
Is that
the 12th, I
Sorry,
believe.
sorry. The administrative leave went through on July.
July 1st?
Yes.
Okay. And the actual duty status hearing didn't occur, and based on scheduling issues, didn't occur until July 8th of 2024. Is that accurate?
Yes.
With respect to July 8th in particular, do you recall a series of questions from Attorney Moynihan with regard to your attempts to speak with him at or around the same time as the duty status hearing and asking him to set up a time for Mike Proctor to come in and give the interview?
I do.
All right. And sir, you were also asked a series of questions about your motivations and the how much emphasis or how much importance you put on the timing of getting that interview done quickly.
Yes.
And you were also asked about how common it was, for example, for you to go to, for example, the counsel of a subject of an internal investigation at the duty status hearing in an effort to set up the duty to it. That's a terrible question. Pardon me. I'll start over. Do you also recall a series of questions asking about how common it was for you to approach counsel for a member at a duty status hearing to set up the interview?
Yes.
And you acknowledge that it may have happened before, but it is somewhat unusual to do so.
Correct.
Can you explain why it happened in this case?
Yes. So typically, when someone gets the duty status altered, that typically happens at the beginning of the investigation. In this case, that did not happen. The investigation began in March. I learned of the content of his text messages when he testified in the trial in June. At that point, I started my analysis of the text messages to include the analysis of his pay station records as AVL. At the time of his duty status hearing, my investigation, the bulk of it had been completed. The only piece that I had left to do was to interview Trooper Proctor. So when I approached Attorney Moynihan, it was an effort to get that interview going.
Let me ask you a couple follow-up questions if I may there, sir. When you said you had completed every other step of your investigation except for the interview with Mike Proctor, did that include some of the exhibits we saw in your testimony yesterday? For example, your collection and analysis of the AVL data, your collection and analysis of the pay station reports, things of that nature?
Yes.
Those were all complete as of July 8th, 2024.
Yes.
In fact, every part of your internal investigation was complete as of July 8th, 2024, with the exception of the interview from Mr. Proctor.
Correct.
Was there any reason to wait to schedule the interview of Mr. Proctor, given that you were at that stage of your investigation on July 8th, 2024?
There was not.
All right, sir. Switching gears once again, I only have two more topics to ask you about. You were shown under cross-examination a series of emails that you shared with.
Didn't she get fired too because she was harassing other people? She worked for a school or something. Well, I believe it's a lot more people. Him, Bukaki, Meatball Morrissey, Berkowitz are all big parts of it, and of course the McAlberts.
A fellow OPIA investigator, the chief of OPIA, Lieutenant Colonel Shoemaker, and Suzanne Caravaggio from the State Police. Is that accurate?
Yes.
And there were a number of emails, including emails presented to you from July 17th of 2024 in particular. Do you recall those emails?
I do.
All right, sir. And do you recall being asked a series of questions by counsel for the appellant with regard to the different permutations or versions that your report went through in July, around the time of July 17, 2024.
Yes.
And one of those, you were asked a series of questions about a new version of your report from the afternoon hours or PM hours of July 17, 2024, that included preliminary recommendations as to each allegation as you put forward in that draft of the report at that time. Do you recall that?
I do.
All right. And you recall a series of questions about whether or not you had reached premature conclusions in this case?
Yes.
All right, Commissioner, may I approach, I handed it up earlier in the hearing when this topic came up before. The two-page document, yes. May you have a copy? May I approach the witness with a copy? I do have an additional. I was just going to ask Detective Lieutenant Dwyer to authenticate it, and then I would be offering it as an exhibit, yes.
Who's donating organs?
Thank you. May I approach counsel and witness?
Deaver hasn't quit. Deaver is on medical leave. Family.
So, handing you a two-page document. Can you just take a look at that for me, please, and tell me if you recognize what you see there?
It was an email that I sent.
All right. And the date of this particular email is July 17, 2024, and specifically sent at 9:05 p.m. and 14 seconds?
Yes.
All right, sir. And if you could just look at both pages and tell me, based on your awareness and your personal knowledge, is this do these two pages fairly and accurately reproduce the content of this email chain as it existed at that time?
Yes.
All right. I would ask that this be, would it be respondents exhibit 37?
Can you tell me who Jeremy Sweetie is again?
Sir, would you please tell the commission who Jeremy
He was a DOT that was sent to OPIA.
All right, sir. I'm going to refer this, well, I apologize.
I admit that is, I'll exhibit 37.
Thank you, thank you. I'll now refer to it.
Thank you very much.
I'll now refer to it as exhibit 37, sir, for clarity. On exhibit 37, is it fair to say?
No, it was a fake news story that sadly didn't get checked. So, as we say in Denmark, a lie is halfway around the world before the truth gets its shoes on. Again, another story that broke on the internet and everyone was reporting on it, but it was later shown that she didn't quit. She's still on medical leave. And yeah, I don't know how long she's going to stay there.
That this particular email was drafted after you had submitted within OPIA.
She didn't go in and didn't quit. She got her license renewed or whatever it's called. She is on medical sabbaticals at this time.
The new version of your draft, which contained those preliminary recommendations.
Yes.
Or preliminary conclusions, is that a fair way of putting it?
Yes.
Works for what?
And
I'm lost.
is exhibit 37, and specifically the two lines at the top that you added at 9:05 p.m. that evening, is that by way of explanation for the new version of the draft?
It is.
Is Brandon talking to Nicola Maxwell or something? Because apparently, I don't know if she blocked me or YouTube blocked her, or I can't, but I don't understand who he's talking to. Who are we killing to get that organ? I don't know.
Could you please read aloud the entirety of those two lines, please?
Yes. Also, and obviously, the recommendations are only based on what we know so far, and it's just a draft. They may be changed based on what we learned from Proctor.
Now, sir, I want to move slightly ahead of exhibit 37, but related questions. The interview of Michael Proctor took place July 19th, less than 2 days later after this email was drafted.
Yes.
All right, sir. And as of July 19th of 2024, following the interview, did you take it upon yourself to conduct a summary and analysis of what Trooper Proctor told you and investigators in that interview?
I did.
Did you, in fact, update your report to include the content of what Trooper Proctor stated during that interview?
I did.
And did you also check the earlier versions that you had entered into the draft copy of the report, the boilerplate that you mentioned before? Did you check that for accuracy?
I did.
Did you also have occasion at that point to analyze and incorporate Michael Proctor's testimony into your findings and conclusions in your report?
I did.
Now, do you recall a series of questions on cross-examination about how the draft copy of your report existed as of July 17th, 2024? a couple days before the interview and the final version as it ultimately ended up. You recall a series of questions about that?
Yes,
You recall questions specifically directed to you as to whether or not any of your recommendations changed after the interview with Mike Proctor.
I do.
Can you tell us why none of those recommendations changed after the interview was complete?
Nothing was learned in the interview that changed the facts as we already had them. For the most part, Proctor had confirmed basically what he had testified to. So the sustained charges were kept. In addition, he also confirmed the charges that we did not sustain as well.
During your interview, did you have occasion to ask clarifying questions or additional questions that were not necessarily asked during the
And we
public
have
trial?
11-0.
Yes,
And did you consider those questions of importance to you in your investigation?
yes,
And with respect to those questions, were you seeking additional information and insight as to whether or not Trooper Proctor's, each individual allegation against Trooper Proctor was accurate
yes,
or was supported by evidence?
correct.
And you had an opportunity to ask all of those questions and Trooper Proctor answered.
Yes,
And did, in answering those questions and clarifying your questions as an investigator, in clarifying the answers to your questions as an investigator, did Mike Proctor give you in that interview any reason to change any conclusions that you have reached as a result of what you knew going into the interview?
No.
All right, so last topic, if I may. Under cross-examination, you were also asked a series of questions with regard to Mike Proctor sharing information about the active homicide investigation with individuals outside of law enforcement. Do you recall a series of questions about that?
yes,
All right. And do you recall being asked if you looked into whether or not certain individuals knew certain facts as of, for example, the evening of January 29, 2022 at around 10:30 p.m.?
I do.
And you recall stating
Thank
in
you
your
for watching,
testimony that it was not relevant to your investigation what the pre-existing knowledge of those other individuals was.
Correct.
Can you tell us why it wasn't relevant to your investigation? What they did or did not know at that time?
Because my investigation was focused on whether Trooper Proctor was authorized or not to send that information, not based on what someone already knew.
All right, sir. As a reminder to the commission, I know you touched on this in your direct examination. As a reminder to the commission, who or what is the entity legally charged in Massachusetts with all homicide and unattended death investigations in a given jurisdiction?
The DA's office.
So the local DA's office and jurisdiction is the legal authority by state law.
Correct.
And are troopers assigned to district attorney's offices required to follow the lead of the district attorney or his or her designees in their office for homicide investigations?
Yes,
And does that include following the lead of the district attorney and his or her office as to what is shared publicly with the media?
yes,
Do you recall testifying in the trial board?
I do.
Do you recall being asked a series of questions under cross-examination at the trial board on this particular topic?
I do.
And do you recall a series of questions designed to elicit from you whether or not you had any information about how public certain information was in the hours following the discovery of John Q's body?
Yes,
As a result of being asked about that at the trial board, as the investigator in this matter, did you have occasion prior to today to go seek out additional information to nail down the timing of when the Norfolk County District Attorney's Office authorized release of certain information?
I did.
So to your, based on the information you tracked down from the source, the Norfolk County District Attorney's Office, when did that office first make a statement about providing any information about the discovery of the decedent John Q's body?
I believe it was in the late afternoon of the 29th.
Based on the information provided by the Norfolk County District Attorney's Office and their provision of information publicly, did they, at that time, meaning the late afternoon of the 29th, did they confirm, for example, that the decedent was a Boston police officer?
I believe so.
Do you recall whether or not on the afternoon of the 29th that they had indicated there was an individual found outside the residence, they were taken to a hospital and pronounced dead?
Yes, that sounds accurate.
Do you recall information received from Norfolk County that it was at 3:19 or thereabouts on January 30th before they confirmed that the decedent was a Boston police
Yes.
officer? Do you recall whether or not when they confirmed that to an outside source, to the public, that the individual was a Boston police officer, did they confirm the identity of the individual, meaning not just a Boston police officer, but specifically Boston police officer John O'Keefe? Did they confirm that at that time on the 30th?
They did not.
When was the first time that they confirmed additional details, including the identity of the decedent and the arrest of Eric Reed?
It was on February 1st.
As part of that process, and as part of your investigation overall, did you have occasion to look for any information, one way or the other, as to whether or not Mr. Proctor, as of, for example, January 29th, 2022, was authorized by the Norfolk County District Attorney's Office to reveal what he did in those text messages?
Yes,
Did you find any information to suggest that Norfolk County had authorized him to reveal that information?
I did not.
Nothing further.
Do you have anything that you want to?
Just a few questions. Just to backtrack, DLT, Michael Proctor was not charged with dissemination of information, was he?
No, sir.
And regarding this non-disclosure agreement, do you have a copy of that?
I do not, sir.
Have you ever provided a copy of that to myself?
I am not.
And do you know if anyone has?
I am not aware of that, sir.
When was the last time you read it?
On March 4th.
And you weren't given a copy, I presume?
I don't recall, sir.
You ever recall having in your possession a copy of that NDA?
On March 4th, I did, yes.
Other than on March 4th.
Not that I can remember, sir.
And so on March 4th, I'm assuming correct me if I'm wrong, you've shown a copy of it
Yes,
and you signed it?
yes,
You read it before you signed
I
it?
did.
So your understanding today is what you recall from March 4th of 24, correct?
It is. It was a very clear understanding.
Yeah, and but you haven't seen that document since March 4th.
I know, sir.
And that's, as far as you know, it's never provided to us.
I would know that, sir.
Now, as part of that process, numerous other people at that meeting were required to sign the NDA as well, right?
Yes, sir.
Colonel Law included,
I would assume yes, sir.
Lieutenant Colonel Connors,
Yes, sir.
and others, Major Caporath, et cetera.
I would assume yes.
And so they were aware of the contents of the text messages, and they were presumably precluded from disclosing them.
Again, I don't know if they're aware of the contents. All I know is that people in that room were aware of the existence of the text messages.
Now, you were shown what I believe is Respondent's Exhibit 26 a moment ago. If you could take a look at that, and its date stamp number. So I think it's 25. 24, Article 5. I'll get to the base stamp. We look at Respondent's Exhibits 643, which was shown a moment ago.
Yes, sir. I'm there.
And this is Article 5, correct?
It is.
And you were shown the category of discipline entitled unsatisfactory performance, correct? 5.8 on that page stamp 645.
Yes, sir.
And you specifically read 5.8.1, correct?
I did.
And you told us that 5.8.2, first of all, that's what Michael Proctor was eventually charged with, correct?
Yes, sir.
You told us earlier that you don't decide what charge Michael Proctor or any trooper is going to be charged with, correct?
Correct.
But you told us that 5.8.2, which is very clear and specific, only lays out possibilities of examples of unsatisfactory performance, right?
Can you ask that again?
You told us on redirect that 5.8.2, first of all, that's what Michael Proctor is charged with, correct?
Yes.
That only lays out possibilities. You recall telling us that?
Yes, sir.
But 5.8.1 is pretty specific.
No, if you go in and listen to what his defense has been saying all day, they never ever attack the reasons why he's fired. They are trying to do but technically, if you read behind the lines, it's never ever kind of maybe what it is that. So, if you close one eye, they never ever try to explain that he admitted he didn't follow the rules. He admitted that he was drinking, all of which is fireable offenses. So I don't see how these people believe this is going to work. Well, it's Massachusetts, so, well, sorry. Of course he's getting his job back. And I need a bio break.
Is it not?
It is. Yes, sir.
And that's the category of unsatisfactory performance, which, as you read, Members shall maintain sufficient competency to properly perform the duties and assume the responsibilities of their positions, correct?
Yes,
Members shall perform the duties in such a manner as will maintain the highest professionally accepted performance standards in carrying out the functions and objectives of the state police. Did I read that correctly?
you did.
And could you go to Respondents Exhibit 26, please?
No, sir.
Date stamp 0669.
I'm ready, sir.
So page 669, date stamp. You see 5.8.1 in the category of discipline and the consequential charge.
I do.
And 5.8.1, the section we just read, I think you were asked to read. What classification of discipline is that?
For 5.8.1,
Yes.
it's class C and D.
It could be class C or class D.
Correct.
And that's at the discretion of the department/term, correct?
Correct.
And so Michael Proctor, if he had been charged with 5.8.1 under the disciplinary guidelines, he could not be fired. Could he?
Under that, yes, under 5.8.1.
That's all I have. Thank you.
Good afternoon, Lieutenant. How are you?
I'm well, how are you?
So I have a few questions for you. Just begin with asking about your background. When did you first join the state police?
In 2004.
And what were your first assignments?
My first assignment was out of Leominster Barracks.
And you were just a trooper?
Yes, yes, ma'am.
And how did your career advance after that?
From the Leominster Barracks, I was assigned to the State Police Detective Unit of Worcester County for about 6 years.
You say that slowly. State
The
Detective
State Police
Unit,
Detective Unit for Worcester County.
Worcester County. Okay. Okay.
From there, I was assigned to the High Risk Victim Unit for about 4 years.
That was also in Worcester.
It was a statewide unit.
And what year did you begin that?
In 2016, I believe.
So you were in Leominster for how long?
Over 5 years.
So then,
About 5 years approximately.
so then in 2009, you went to the Worcester County.
I was beginning 2010, I believe.
And then after you left the high risk unit, where'd you go next?
From there, I went to it's called the Public Response Unit.
And that's also statewide?
It's a statewide, well, it's a unit that's based at headquarters
Which is where?
in Framingham.
So please no acronyms and just
I apologize.
give me all the late for this. What year did you go to the public response unit? What year was that?
2020.
And you attended the State Police Academy?
I did, yes.
And Lieutenant Dwyer, what is your level of education? Where'd you go to school?
College.
College. Did you do an advanced degree?
No.
And when you joined, when you were at the police academy and after, have you had any trainings since you were hired?
On the state police?
Yes.
Yes.
Investigative trainings and
Yes.
internal affairs trainings?
Yes.
Can
Yes,
you
we
please
have.
describe those?
There's been numerous invest trainings when I was in the detective unit for crime scenes, homicide trainings. I've been trained in sexual assault investigations, human trafficking investigations, multiple IA investigations. There's been a bunch over the years, but those are the ones that stand out to me now.
When did you become a detective lieutenant?
In 2021.
All right. So I just would like to go over some of the work you did on this matter. So I'll ask you please to turn to Exhibit 19.
The respondent or the appellant?
The appellate, Exhibit 19. So this is case stamp appellate 107.
Is it 19, ma'am?
Yes, so it's case stamp page 107.
Yes, ma'am.
All right. So this is dated June the 26th.
Correct.
So is this product the result of your first draft?
No,
What is that?
no, ma'am. This product was a result of watching Trooper Proctor's testimony at the trial and the notes they took. This was generated just to draft an idea of possible violations would have been.
And this, there was another exhibit where you took the notes as well. This was based on that exhibit where you submitted on just notes?
So those notes probably weren't finalized until after that one. It was this draft here was probably based off of all the hand notes that I took.
All right. Someone tell me which exhibit was detective's notes on watching the testimony?
I apologize. I believe it was response 8.
Yes, that makes sense. Yes. Respondents' notes. So you testified earlier that you made those.
They don't want to hire him. Again, I've said this multiple times. They don't want to hire him. But the union is trying to force this judge to reinstate him. The police have fired him. The police have sent 2 lawyers to argue why he shouldn't be reinstated. And the union has sent 3 lawyers to try and convince this judge that he's just a good boy who got mad. So all of this is because unions are stronger in America than most other places, and they will try and force whatever they will through. This is how union works. They don't care about Proctor. They just want him back in there so they can get their membership fee.
Those respondents exhibit 8, and then this letter later after watching the testimony. Live
No,
stream.
ma'am. The notes that are the exhibit, I don't know exactly when they were created, but they were most likely created after I drafted that document.
The notes from the video from watching the live stream.
Yes, the notes are the exhibit. That was my final draft. It was 2 days of testimony.
Yes.
So I spent 2 days just writing notes down. That is not what is Exhibit 8. The Exhibit 8 is me compiling all the notes that I took while watching the trial. I also generated this document here from the handwritten notes that I took from watching the trial.
So I'll just ask you to look at
I believe she's the only one, yes.
which is on page 107.
Yes, ma'am.
So you have at the end of that paragraph that the conduct identified in that paragraph could be, your very last sentence says, this could be a potential violation of rules and regulations 5.23.
Yes, ma'am.
And I believe we said that 5.23 was dissemination of information.
Yes, ma'am.
So I believe that is in respondents 24. Return to that, please. So that's page 652, respondents, page 652.
Yes, ma'am.
And as you look at these, it looks like it goes to about 10 sections, 5.231 through 5.2310.
Well, they have the defense that, hey, someone else is also a bad cop. And it was his private phone, even though he used it to contact police officers, which makes it a not private phone. It's not a good defense, but hey, they're trying. And did you know that in paragraph 37, subsection 2/3-5, subsection G to subsection F, it doesn't say mobile phone? So it's really, can you fire him? Again, notice they have done nothing to attack that what he did was wrong. They only circle around it and say, well, it doesn't specifically mention that you can break the laws on a mobile phone.
Which section were you considering that this could be a potential violation of?
I'm not qualified to speak which section it is. The purpose of this document was to highlight possible violations. So when I pointed out 5.23, I was addressing the fact that those texts could fall under one of those subcategories in the greater category 5.23.
Okay, so who would be qualified to decide which section it would be after you draft this?
The personnel that are involved in the process to decide discipline. That would be the DSC command staff, the legal section, the prosecutor, among others.
But if you can just please look at that page 652,
Yes, ma'am.
and looking at those sections, I mean, they're quite, I would say, different kinds of acts. Which ones would you think would match that conduct of the text messages being sent out to different people?
I mean, I don't know if I'm qualified to make that call.
How'd you choose 5.23?
So I knew that he was sharing information, which would be the dissemination of information. So I know that the broader category, 5.23, the overall one, is the dissemination of information. It would be up to the person who decides actual charges to go through that category and pick the specific subcategory.
So at the time that you wrote this document, who did you think would be the person to decide that?
So this document was not designed to recommend charges.
Mhm.
This document was just to let my bosses know this is the violation that I occurred. These are what the possible violations may be when the invest is done. This document was generated well before a report was done or I was near the end of the invest.
All right. The same thing on paragraph 3, the same page. The last line says this could be a potential violation of policy and procedure ADM-47 bias-based policing and ADM-18 unlawful harassment/sexual harassment.
Yes.
And what made you choose those?
Again, based on the nature of the text messages, I was just making sure that I encompassed all possible violations. Again, this document was not meant as a recommendation for possible charges. This was just a document what the possible violations may be as the investment forward.
And then on paragraph 4, if you turn the page,
And what the judge is doing now is what the defense should have done. Why did you choose these specific subsections? Why do you feel this is the ones we should use, or the ones who determined he should be fired should look at? This is what the defense should have done, but the defense didn't do it. The defense just sat there and said, well, it's not like he called her a flat-assed hoe. Come on now.
the last sentence, this could be a potential violation of rules and regulations 5.10.4.
Yes, ma'am.
And what was your consideration of including that? It's page 108. Paragraph 4.
Yeah, appropriate rule.
Because she needs them to illuminate. And this is not good for the defense that they didn't go into it. This shows me that she wanted them to ask these questions. And again, this is a civil procedure. It's not a criminal case. She is, I believe, the fact finder in this. She's the judge, jury, and executioner in this case.
Because that one specifies that they should not consume alcoholic beverages. So that one was pretty simple to bend down.
So that was one you decided on your own.
There was no other option for that one. Yes.
Thank you. So the other question I had is, when you were investigating the issue of the text messages and dissemination, did you consider, did you view it as multiple violations
I did
or one violation?
multiple violations.
How many violations do you think occurred?
Well, so there were 4 separate text conversations. So I viewed each text conversation as its own incident.
So would you consider them, so you're looking at 4 separate, so basically 4 separate chains,
Correct.
4 separate dates,
Multiple dates.
multiple dates.
Correct.
So you were looking at them as more than one offense then? Would it be a first offense? How did you look at it?
For charging purposes,
Yes.
I don't make that comment.
I just want to look at one more item. Do you recall this morning that Mr. Moynihan went over with you potential charges that you received from Mr. Maggi?
Yes, ma'am.
And do you recall that he described that, if you could turn to exhibit, it's actually date stamped 172, I believe it's exhibit 32, appellant's exhibit 32.
Yes, ma'am.
And this is where we have to look at more than one exhibit to get the information. I believe it's also responded exhibit 26.
No, I believe she's the one who has to
Danger
make
of
the
double-sided
decision.
copies. So respondents exhibit 26.
Proctor's union reps wants Proctor back.
You see on page 667.
I do.
So there are there are classes of guidelines,
Yes.
A, B, C, and D.
Yes.
And do you recall this morning when Mr. Moynihan went through disseminated information, which is 5.23
Yes, ma'am.
and 2, and he went through each clause with you?
Yes, ma'am.
Do you recall that for first offense, and 5.232 is a class C,
Yes.
and that for a first offense, if you look on page 667, is a written amendment up to and including suspension for not more than 5 days,
Correct.
and that's for a first offense.
Yes, ma'am.
I'm not gonna look at the alcohol, the 5.10.4, but on the unsatisfactory performance, which is 5.8.2,
Yes, ma'am.
which was terms of class A. And do you recall that under the first offense, a suspension of not less than 30 days, but up to and including termination for a first offense?
Yes, ma'am.
Mr. Carley and Mr. Moynihan, was there an ADM 47 admitted as one of the articles?
I don't believe so. It was produced in December, and I don't believe I was part of it.
Yeah, it got mentioned in one of the exhibits, but it wasn't submitted. That's fine. I just know I know I read it somewhere.
I apologize, I don't believe it was marked, but I should be happy to provide it.
Yeah, Yeah, because it is mentioned, and I was just wondering what it said. So I think that was the ADM 47 that's mentioned. It's mentioned in Exhibit A19 in paragraph 3. And that's what I was trying to figure out what it was. So if one of you could submit that,
I'd be happy to.
thank you. Excuse me.
Come on. Come on.
All right, thank you very much, Detective Lieutenant.
Thank you, ma'am.
Can I ask a clarifying question?
Yes,
That only with regard to the Commission's request for 8847, which I'm happy to provide. And as the Commission may be aware, the Department's policies and regulations go through multiple versions over the
course.
years. Is there an effective date, or is there a date range that I should target? I'm happy to submit multiple if necessary.
well, I would be interested in the one in effect on the date of the letter, which is June 26, 2024. And if it's overly, and actually the second one is, well, there's two of them, ADM 18, unlawful harassment / sexual harassment. So the two documents.
I'll produce both that were effective on this day. Thank you.
Thank you very much. Do you have any further questions for Lieutenant?
I just believe, I'm curious if the department's question, they didn't want to make this big.
Right, I think I'm just saying,
I don't know.
based on the questions I just asked, I guess that is what I meant. Do you have anything further for your comment?
Nothing for this witness.
Mr. Moynihan, you wish to as well?
I have nothing else for this witness.
Okay. Well, Detective, you've had a long day, and thank you very much for coming in.
Thank you.
You're excused. Yes. Did you two me a peace approach?
Are we done? First offense, but they counted for them. Yeah, but that's kind of the thing. If you want to do crime, do it at the same time, because it'll give you a discount in court. Yes, the defense will be back in October and present their side of the case. I think we're done for today, but we'll hang around and see. It's been long, it's been tedious, and the last hour is the only thing, the only hour where we had anything of relevance asked. The rest has just been, well, you can't really find him guilty because he's such a nice guy. It's I can't see where what defense they're gonna come back with. We found 25.
Good afternoon again. So the time is now 3:12. We're going to adjourn until October 21st, 2025, and we'll meet back here at 9:30 a.m. Thank you all very
Bye.
much. Have a good afternoon.
But they are asking for, I believe, 200 other cases of misconduct by police officers to try and say, hey, yeah, he's a bad guy, but he's not better than all the other bad cops. But the only thing we haven't touched today is why they believe what he did was okay. Why they don't believe that him breaking the rules, I just have a hard time figuring out what the hell they think they're going to win by this. I'm really confused at what tactic they think will work. If it's, well, he's bad, but he's not that bad. I'm not sure that's a good argument. He's bad, but the other cops are just as bad. I'm not sure that's a good argument either. Help me out, chat. What the hell are we on about? I really don't understand what they're trying to get to. It's confusing the hell out of me. I just don't get it. I'm sorry, I just don't get it. Honestly, if he can provide examples of other officers doing the same without being fired, he'd probably get his job back. Yes, but I'm not sure it's going to be so easy because he was drinking on the job. That's an automatic fireable offense. Could he have found other drinking on the job? Yes. I don't think it's looking good for him. I have to be honest to say, I think he's pretty toast, because who the hell wants him back? That's the big question. The union reps has to fight for him, of course. They have to do that, but I just don't see it. I read the papers. I think they didn't go too far in the charges against him. They let him slide on a lot of the stuff they could. If they just wanted to kick him out of there, they could have done the gift shit and him knowing the witnesses as well. But I just don't think I don't think it's going to be easy for him to come back. Yeah. Yeah, and I know that they'll claim, well, we get paid less, and that's why we'll get better protection. But I've seen what these guys hold in every year in their paychecks, and they get paid a lot. His payment on his pension is roughly what a minister get in the Danish parliament. No, none of this. Let me be Debbie Downer one more time. I need to go to Mo and borrow a wig so I can put it on every time I'm gonna shit on everyone's parade. They are not investigating anything again. Never. Karen Reed is done. The only reason to this police department ever looking into the murder of John O'Keefe again will be if that 1893 or whatever that case that she might file against the police department. If that gets legs, they'll have to look at it again. But other than that, they will never mention John O'Keefe's name again. They will never mention Karen Reed's name again. She beat them twice. They will never, ever look at anything related to that investigation again. Never. If Proctor gets reinstated, he'll be put in a broom closet and he will be sat in there counting paper clips every day. And hopefully he'll quit at some point. That's what they're going for. They will never, because it wasn't Proctor who fucked up the investigation. It was everyone. He was just the lead investigator. He couldn't do it on his own. You would have Bukaki, Tully, Morrissey, not Levy. Who's the guy who went into the house that I always want to call Tully? The first one at the scene. Come on. The one who went into the house. You need to talk to all of these people. You would rather have Proctor sitting in a closet counting paper clips for 3 years until he's eligible for his pension and then say, hasta la taco, get out of here, than you will ever touch the investigation into Karen Reed. Do you know how deep down shit creek they are if the Sandra Birdsmore case gets more people rolled into it? They are way more trouble about the Sarah Birdsmore case than they are, because they know the feds are never going to go back to the Karen Reed case. It's just a mirage that people are telling you, well, they're going to do this. No, they're not. The only case they are afraid of right now is the Sandra Birdsmore case. They're not afraid of the other cases that Proctor has covered, because the judges will allow as much as possible in, and they'll get their convictions. I saw what she allowed in the Walsh case. It's absolutely nothing they're going to lose because of what Proctor touched. So he's toast. He's going to be found guilty. What they really fear is the Birdsmore, because that's federal. And they can't control a federal case. They can control whatever they want because they have the nice judges, they have the nice police officers, and they have the nice DA's office. So all of these people will suck each other's cocks and make everything go away. And I'm sorry, you want me to tell you that the Cowboys is going to come save you. They won't. Birdsmore is the only problem they have right now, because that's federal. Doesn't matter if he was in charge. You need all the other cops will be the same problem. What the hell's wrong with my earbud? I don't know if StreamYard has been a very glitchy lately. If he was fired, then why did he get a union lawyer? Because he's still a member of the union, and you are allowed to go to your union and say, well, I don't believe I was fired on the correct for the correct reasons, and your union will have to do an inquiry and try to get you your job back if they say, well, unless they come and say, well, you did show up every day drunk, we can't do this. But this is part of paying your union dues. I watched my first trial I covered was a Border Patrol agent who unalived his girlfriend and their baby. And he had, I think, 8 lawyers paid by the border agent union because it's part of your benefit. It's the insurance you buy with a union. So this is why if you get unemployed tomorrow, you'll have, if you are part of a union, you'll have their legal team on your side as well. So of course he has access to union lawyers. Oh, she didn't lose her job. I thought she got fired when she called people. I may be wrong. That's why I'm 50-50 on unions. It's way too hard to fire bad people, even if you do the appeals costs so much resources. Yeah, it's good when they say good people, but it's bad when they keep bad people in office. But that's the trade-off. Because everyone who's a member has to have the same rights. But I'm just feeling he's not getting his money worth with these lawyers. Lank, Sergeant Lank, that's the guy I was looking for. Sergeant Lank. He's the guy. Yeah, well, let's see how bad this judge will go in October, because if she reinstates him, he's still on track to get his pension back. And this is all about his pension, because he's 42 years old. He's unhireable. So he doesn't want to go out there and start over again. What job can he get? He's a disgraced police officer. So he wants his pension. I had a young woman I hired in the union, and the nasty women in the union treated her horrible. I had one. Christmas is pretty busy in bakeries because first you have Christmas, then you have New Year's. And our boss called us all to a meeting and said, hey, we really want you to do overtime. Is it okay with you? And we can make a deal if you want to get paid, or you want to have, you'll want to take time off to pay it, so with pay. And I went in and said, I want signed on a piece of paper that you're going to pay me every single hour of overtime. Well, no, it's cool. I said, no, I've been in this situation before, and it's always a hassle to get overtime. So I blah blah declare that Baker is going to get paid for every hour he works overtime. And I did like 42 hours, so I actually worked a week extra in December. Work week is 37 and a half hours in Denmark. And when I came to collect, and I said, yeah, you owe me for 40 hours. Yeah, well, we can't pay that because it's not in our budget. You need to take time off. I said, nope, I have a piece of paper. Yeah, well, we're not going to honor that. I said, that's fine. I'm going to go to the union. And I thought, this is a slam dunk case. I'm going to get my monies. And the union said, no, that's such a big company. We don't want to fight them. So unions are not my friend. I missed the hearings. They convinced me that I will never, ever, ever rewatch those streams because it was so boring. I think I got more gray hair. I can't see that they can find enough there because, again, the rules they went by was so broad that just because it didn't mention a mobile phone, it's still a violation. But yeah, But we'll see. We'll also see what we're going to do tomorrow because I don't know. Maybe something pops up, something might not pop up. And if you are going to watch anything tonight that's going to make you even more heated than this, go watch the press conference with the young missing kid, presumed dead, Hero, however it's pronounced, out in California. They are having a press conference and attacking people for asking questions because, oh, you're hampering our investigation. It's not like they're running around out there looking for the kid and they're blaming the press for asking questions. I got so hot under the collar when I watched that. Maybe you'll do it too. But I'm going to jump off. Hope we'll find something tomorrow. If not, we'll do something some other time. Love y'all. See y'all. Bye, y'all.
What exhibit are you referring to?
I'm going to make this 100, Your Honor.
All right.
100.
100.
Because it is 100%.
100%.
correct.
So you literally built a cannon?
Yeah, it's pretty awesome.
All right, I'm in love.
Go back. Please do that again. Oh, that was the cutest thing I've ever seen.
While I'm waiting for this, did you, whether it's true or not, believe that Mr. Randolph had slept with your wife?
I wouldn't have cared.
You wouldn't have cared?
No,
Did you believe he had slept with your wife?
no,
Did you believe he slept with your mother-in-law?
probably did. Everybody has.
So there-
Everybody has.